My lord, may I seek
Hmm?
may I seek your permission to mention a matter?
No, tomorrow. Oh.
Supplemented daily. Item number 3.
Item number 3. Due to two
Just a minute. ଏଠିକି ଆସନ୍ତୁ କଣ ଆପଣ ନାଁ କଣ
Regan Kindo, sir.
ହଁ
Regan Kindo.
You are the IAC
Sir.
of Model Police Station,
Sir.
ମାଲକାନଗିରି
Sir.
କେବେଠୁ ଅଛନ୍ତି ଆପଣ?
2023.
ହଁ
2023.
2023ରୁ ଯେତେବେଳେ ପ୍ରଥମ ରିପୋର୍ଟ ଏଇ କେସ୍ ସଂକ୍ରାନ୍ତରେ ଆପଣ ଦେଲେ 8/5/2025ରେ ଆପଣ ଦେଖିଲେ ଯେ ଆପେଲାଣ୍ଟସ ଏ କେସ୍ର ଯୋଉମାନଙ୍କୁ ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଛି ସଞ୍ଜୀବ ଓରଫ ସଞ୍ଜୀବ ମଣ୍ଡଳ ଆଉ ଆମେଲା ବାରୋଇ ଓରଫ ମଣ୍ଡଳ ସେମାନେ ବଞ୍ଚିଛନ୍ତି। ତାପରେ ପୁଣି ଆଉ ଗୋଟେ ରିପୋର୍ଟ ଦେଲେ ତାର 5 ମାସ ପରେ 27/10/2025ରେ ଯେ 2 ଜଣ ଯାକ ଆପେଲାଣ୍ଟ 10 ବର୍ଷ ଆଗରୁ ମରିଗଲେଣି। ତେଣୁ ଆପଣଙ୍କର ଏଇ ଯୋଉ 2ଟା ରିପୋର୍ଟ ଯୋଉଟା 5 ମାସ ଭିତରେ ଆସିଛି ସେଟା ଟୋଟାଲି କଣ୍ଟ୍ରାଡିକ୍ଟୋରି ଟୁ ଇଚ୍ ଅଦର। 8/5ରେ କହୁଛନ୍ତି 2 ଜଣ ଯାକ ବଞ୍ଚିଛନ୍ତି ଗାଁରେ ଅଛନ୍ତି, ତା 5 ମାସ ପରେ କହୁଛନ୍ତି 10 ବର୍ଷ ହେଲାଣି ସେମାନେ ମରିଗଲେଣି। ତେଣୁ ସେଇଥିପାଇଁ ଆମେ ଆପଣଙ୍କୁ କହିଥିଲୁ ଯେ ଗୋଟେ ଇନକ୍ୱାରି କରିବେ ଏବଂ ଇନକ୍ୱାରି କରିକିନି ଗୋଟେ ଫ୍ରେଶ ରିପୋର୍ଟ ଆପଣ ଦେବେ ୱିଥ ଆଫିଡେଭିଟ୍। ତେଣୁ ଆପଣ କଣ କଲେ?
Para 7 there. Personally inquired.
ପାରା 7
In obedience to order details certain present deponent personally inquired into the matter in the above in the native village MPV3. There is brought to the notice of the present deponent that both the applicants have left the native village since long, and thereafter it is brought to the notice of the present deponent that both the applicants presently residing in thatched house constructed over government land in village MB3 near RT office along with the mother of the applicant number 2. It is further to submit here that on personal inquiry by the present deponent, there it is brought to the notice that the applicant member is working as a helper in truck used for transport of goods to other states. Very often he moved to the MB3 thatched house where his mother-in-law is residing. Similarly, the applicant number 2 is concerned. She is engaged as a daily wages laborer and used to go to the state of Andhra Pradesh and Bangalore for her livelihood. Therefore, detailed information could not be collected by Sub-Inspector Prithviraj Behera, for which inadvertently under misconception is submitted on 2010 about the death of the applicant, neither intentional nor deliberate, for which the present deponent is being unconsidered. Thereafter they mentioned that he has contacted para 10. Appellant number 2 contacted over telephone. She was assured to present today, but she did not turn up. The sub-inspector concerned is there in that house where the mother-in-law of the appellant number 2 is residing.
Hmm.
That house
Oh, right now.
right now.
So,
Sir, namaskar.
Both are left the village, and after knowing the same, the police called. They did not turn up.
no, have they engaged any counsel? You
Yes, yes. Jugal Kishore Pandai.
You were there. And you had no information about this appellants.
ଆପଣ କଣ ନା କଣ?
प्रभात गुप्ता
ଆଁ?
Sir, namaskar. Prabhat Gaur.
Gora.
ଦେଖାନ୍ତୁ ସେ ଯୋଉ ତାଙ୍କର ଯୋଉ ମା appellant 2 ର ମା ଅଛି, ଦେଖାନ୍ତୁ ରିପୋର୍ଟ।
ନାଇଁ ନାଇଁ ସେ ହଁ ଇଏ
appellant 2 ର mother।
ସେ
Amela Baroita.
ଅମେଲା ବୁଢୀ କୁଆଡେ ଯାଇଛି?
ଆମର ବୋଲଙ୍କ ମା ହେଇଛି।
ହଁ, କୁଆଡେ ଯାଇଛି ସେ ଅମେଲା ବୁଢୀ?
କୁହନ୍ତୁ।
ଆପଣ ପୁଅ ନା ହଉଛି ଆମେଲା ବାରବି? ଜ୍ୱାଇଁ ଅଛି।
संजीत हला
ଆମ୍ବଲା ତାଙ୍କ ଝିଅ।
ପାଇଏ ଜମାଇ କାମ ହେଇଗଲେ
ବାଂଲାରେ ଓଡ଼ିଆ କହିପାରିବେ ସାର୍ ବାଂଲାରେ କହିବ
हाँ से तो रिपीट
ଆଚ୍ଛା ସଞ୍ଜିତ ହଉଛି ତାଙ୍କର କଣ?
ज्वाइन
ଜ୍ୱାଇଁ।
ଜ୍ୱାଇଁ ଆଉ
আর
ଯିଏ
নাতি আছে
ଆମେଲା
ହଁ।
ହଉଛି ଝିଅ। ଆଚ୍ଛା
সঞ্জিত তার জামাই হয় আর অমিলা মন্ডল দিওয়ার
ଆଚ୍ଛା କୁଆଡେ ଗଲେ ସେମାନେ?
ସେମାନେ କାମে গেলা
काम में
କାମରେ ଯାଇଛନ୍ତି।
କାମରୁ ଏଇଠିକୁ ଆସୁଛନ୍ତି ତ ମଝିରେ ମଝିରେ?
ମଝିରେ ମଝିରେ আসে
କେବେ ଆସିଥିଲେ?
ଏବେ ଲାଷ୍ଟ କେବେ ଆସିଥିଲେ?
କେବେ ଆସିଥିଲେ?
তবে আবার আসতে অল্প দিন হয়েছে তো পয়সা করে কইলে পরে আসতেছে আবার।
ଅଳ୍ପ ଦିନ।
ଆଉ ତମେ କେମିତି ଯୋଗାଯୋଗ କରୁଛ ତାଙ୍କ ସାଙ୍ଗରେ? ପଚାର ତାଙ୍କୁ।
না স্যার আমার আমার যাদের কোনো
ତାଙ୍କର କିଛି ଫୋନ ନମ୍ବର
মোবাইল
ଅଛି? ଫୋନ ନମ୍ବର ଅଛି ଯୋଗାଯୋଗ
না
କରିବା?
স্যার ওরা ওকে যা মোবাইল নেই
ମୋବାଇଲ ନାହିଁ।
ମାନେ କି ତାଙ୍କ ଝିଅର ଅଛି।
মোবাইল নাই ওকে যা
Number was contacted by the IS.
ଝିଅ ମାନେ ଏଇ ଯୋଉ ଇଏ ଆମେଲା?
That we have mentioned the contact ସିଏ କହିଥିଲା ଯେ ସିଏ ବୋଲି। But we have mentioned in
ଆଚ୍ଛା
କୋଉ paragraph ରେ?
ଆଚ୍ଛା ପାରା
para
10
page 6 ରେ।
ନା ନା ପାରା 10 ର ଇଏରେ
para 10 ର last
Last line.
part page 6।
the cell number of appellant number 2 is 637
ଆଜି ଏଇଥିରେ ଯୋଗାଯୋଗ ସିଏ assured କରିଥିଲା to present today because husband is out of state।
ଆଚ୍ଛା ଏଇ ଯୋଉ ରିପୋର୍ଟ ଟା ଦେଇଥିଲେ କିଏ ଦେଇଥିଲେ? ସେ ଯୋଉ ମରି ଯାଇଛନ୍ତି
सब रिसर्च
ହଷ୍ଟେଲ ଗୋଟେ ଏନକ୍ୱାରି କରିବା ପାଇଁ
କାହାକୁ କହିଥିଲେ?
ଏସଆଇ କୃତିବାସ ହେରାଜ
ନାଇଁ substitute administrator some villager signature are there 25-30% ନାହାନ୍ତି। with that conjunction that Mr.
they took a exams
ଆମର ଯେତେବେଳେ ଏଠି ହାଇକୋର୍ଟରୁ ଗଲା ଆପଣ ଜଣକୁ ଏ ସବ ଇନ୍ସପେକ୍ଟରକୁ ଆପଣ ତ ଦେଇଥିବେ ନା ବାହାର ଦେଇଥିବେ? ସେ ଲୋକ ଅଛି ବର୍ତ୍ତମାନ କୃତିବାସ ବେହେରା ଆପଣ ଥାନାରେ?
ସାର୍
ଆଁ
ସାର୍
ଇଏ କିଏ ବର୍ତ୍ତମାନ କୋଉଠି ଅଛି?
ପ୍ରଭାତ ଗୌଡ଼।
ଇଏ ପ୍ରଭାତ ଗୌଡ଼
ଆଉ ସେ କୃତିବାସ ବେହେରା ଗଲା କୁଆଡେ?
ସେ ଥାନାରେ ସାର୍ ଅଛି
ହୁଁ?
ଥାନାରେ ସାର୍
ତାପରେ ତା କଣ ନେଇଛନ୍ତି ଆକ୍ସନ? କଣ ଆପଣ
ତାକୁ
ନେଇଛନ୍ତି?
ଏକ୍ସପ୍ଲେନେସନ ମଙ୍ଗା ହେଇଛି
ଆଁ
ଏକ୍ସପ୍ଲେନେସନ
କଣ ଏକ୍ସପ୍ଲାନେସନ? କଣ ସେ ଦଉଛି ଏକ୍ସପ୍ଲାନେସନ?
ସେ କହିଲା ମୋର ଭୁଲ ହେଇଯାଇଛି ଆଉ ଗାଁ ଲୋକଙ୍କର ଭର୍ସନରେ ମୁଁ ଦେଇଥିଲି ଫର୍ଦର ଆଉ ଏମିତି ହେବନି।
ତାର କନସିକ୍ୱେନ୍ସ କଣ ହେଇଥାନ୍ତା ଜାଣିଛନ୍ତି ତ? 2 ଜଣ ଆଜୀବନ କାରାଦଣ୍ଡ ତାଙ୍କୁ ହେଇଛି। ଆପଣ ରିପୋର୍ଟ ମଗା ହଉଛି ଯେହେତୁ ସେମାନେ ଓକିଲଙ୍କ ମୋ ସାଙ୍ଗରେ ମାନେ କଣ୍ଟାକ୍ଟ କରୁନାହାନ୍ତି ଏବଂ ଆପଣ ରିପୋର୍ଟ ଦେଇ ଦଉଛନ୍ତି ସେମାନେ ମରିଗଲେଣି ବୋଲି, କେସଟା ଆବେଟ ହେଇଯାଇଥାନ୍ତା ତାମାନେ ସେମାନଙ୍କୁ ଆଉ କିଛି ହେଇନଥାନ୍ତା, ଆମେ ବିଚାର କରିନଥାନ୍ତୁ ସେ ଅପିଲ। ତାହେଲେ ସେ 2 ଜଣ ଯାକ ମାନେ ଏମିତି ପଳେଇ ଯାଇଥାନ୍ତେ ନା ଆପଣଙ୍କ ଭୁଲ ଯୋଗୁ।
ଭୁଲ ହେଇଛି ସାର୍ ଫର୍ଦର
ଆଁ?
ହେବନି ଭୁଲ ହେଇଛି ସାର୍ ଫର୍ଦର ହେବନି ସାର୍।
କୁହାରି ଯୋଉ What is that explanation which you have called for, and what is the explanation that has been given?
ନାଇଁ
Upon, are you the authority? ଆପଣ ଯୋଉ explanation ସେ ମାଗିଲେ ସେ ଦେଲା, ଆପଣ ଧରିକି ତାକୁ ଚୁପଚାପ ବସିଗଲେ, ତାକୁ କ୍ଷମା କରିଦେଲେ। ୟାର magnitude ଟା କଣ ହବ କିଛି ବୁଝିଛନ୍ତି? Why action will not be taken against you? Because it is you who has, we have not asked him to investigate or to inquire into the matter. You have told him to inquire. It is your responsibility that authentic report comes to this court.
ଭୁଲି ଯାଇଛି ସାର୍ ଫର୍ଦର ଭୁଲି
अरे कहाँ भूलेगा? After you received the report from your sub-inspector, did you send it to the superintendent of police? How you are taking action? How could you stop it? Who authorized you to call for a report? Did you report to the superintendent of police, and in compliance of that you have asked for the report?
ଆପଣ ଏତେ ଜିନିଷ ହେଇଗଲାଣି, ଆମେ ମଧ୍ୟ କହିଥିଲୁ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସ କୁ ଇଏ କରିବା ପାଇଁ. What action has been taken by the superintendent of police? He was asked to monitor this. Whether he is present today? Superintendent of police को कौन तो present रहे? फोन करम तम जॉइन करियो कौन? We are deferring this matter. हमें रखुची तम कौन जॉइन करी? Taking it very lightly, na?
One thing I may submit not, he is in the conference, SP and collector conference when he is in.
Asked him that the court has asked him to join.
Wherever he is.
You made a call to him. And he should join within 5 minutes. Yes.
Item 1.
Item 1 minute. Report of the Circle Jail Sambalpur that they are religion bail, but so far the well-being is concerned, they have not received the well-being from the IAC.
Why? This order was passed on 4/9 and we are in month of November. When you have written letter to him?
Madam. (10/9) where it is.
So when they have been released on bail? By the order of this court?
Yes, madam. 8/7/11.
8/7/11. So 8/7/2011, if they have been released on bail, how did you call for a report from the superintendent of the jail? It's a total non-application of mine.
We are calling for the superintendent of Balangir as well as the IIC.
Superintendent to कही ऐसे bail नहीं करानी.
But the IIC has not given the well-being.
Why he has not given? When you have given that?
But I have to send the letter on 10/9/2025.
10/9/25.
So for 2 months he is sitting over the matter.
कौन तो join करियो? कोर्ट या IIC से? बरपाली कौन तो join करियो उसे? IIC बरपाली कौन join करियो? Yes, next case.
Item 2.
Two ballots are similar. With like A is the report from the superintendent of jail.
Again, same thing. He has been released on bail. So that you have given in But we asked you to obtain instruction from the IAC, Borgod. Bonaigaon. Have you written letter?
Yes, my lord.
When?
My lord, on 24/6/2025.
Let phone to Hajar IAC Bonaigaon.
जब पूर्व से फॉरवर्ड
नहीं इधर लगता है इधर ऊपर लगता है इसे मुझे पट्टी करनी पड़ेगी. So this is item number. Next case.
Item 4.
My lord, obtain instruction in this matter has been intimated.
What about 3?
The
वो अच्छा इधर जुड़ा.
matter I have already placed on his implementation. It has been forwarded to the regional official lordship for approval and the consideration and approval. That it has been intimated to the petitioner, your lordship. Now I have instruction that they have received the approval from the regional office for payment.
disbursement.
You are not giving any document.
Documents. This letter I am giving because since the project that is not available, so it is the letter could not be signed. So therefore, I don't have a signed copy of the letter. But this intimation, as per the representation concern, it has been already been forwarded to her. The petition that your representation has been forwarded to the regional office for
Approval and disbursement.
Disbursement, approval and disbursement. That letter it has been intimated as per the representation is concerned. Your lordship's order.
Yeah. Our order is that
To consider the representation.
take a decision on the representation.
Yes, your lord.
So you have not taken the.
My lord, the decision actually the order is up to the Bhubaneswar PD. Actually, the Barampur PD has to it is within the jurisdiction of Barampur PD. So therefore, it has been sent to the Barampur PD. Barampur PD after this wrote letter to the regional office. Regional office now have the instruction that they have approved.
That means you have already fixed the amount.
Yes, everything is in
That
fixed.
is 15,70,593.
Yes.
Is referred to competent authority NHI for scrutiny and consideration.
And it is in approved. I have instruction now. It is in approved. But since the project that is not available, so letter could not be sent.
We'll go by this.
The short date over in the meantime, but the representation is already been taken into consideration.
No, that this is the thing. The prayer is that now it has been decided and you are to get this amount.
Yes.
So that is not the purpose of the contempt. We are just mentioning all these things and disposing of this weapon. The Mr. Santosh Kumar Dwivedi, Land Council appearing for the NHI, produced the letter dated 14/11/2025 of DGM bracketry T and project director, which is addressed to the petitioner Surna Prabha Ratho, and forwarded to RO NHAI Bhubaneswar, CAL Ganjam and others, wherein it is mentioned that the representation dated 14/6/2024 of the petitioner regarding release of compensation amount of fruit bearing trees along with solatium and interest amounting to rupees 15,78,593 is referred to the competent authority NHAI RO Odisha for scrutiny and consideration. And upon receipt of the approval of the competent authority RO Odisha, necessary action will be initiated for release of the compensation. The letter is taken on record. The contempt proceeding is closed. Yes.
Deep.
You see, you are going beyond the prayer is something else. Representation now they have quantified your amount and it will be disbursed. Yes, next.
Item 5.
Item 5 is an official option.
The specific direction given by my lords is at page 12, my lord, para 5 and 6, wherein he was asked to consider my representation on the allegation laid before the authority. Is the opposite party number 5 in the writ petition. So that order has been communicated to him since 12th of August 2024, my lord.
Where have you stated that?
It is at annexure 2, my lord, page 30.
Paragraph number 4 you have mentioned.
Yes, my lord. But till date, no steps has been taken.
So it go. So from this content proceeding, the petition has been filed by the petitioners for compliance of the order dated 29/7/2024 of this bench passed in WPC number 17030 of 2024. The operative portion of the said order reads as follows. Paragraph number 6. The Learning Council for the petitioner drew the attention of this court to the averments taken in paragraph number 4, which indicates that the petitioner approved the opposite party of the contender on 12/8/2024 by filing a representation along with the certified copy of the order of this court, and also sent it through the post. And it was forwarded to CGN Land Issue and Divisional Head Issue, Balasur. But till date, no action has been taken on the to comply the order of this court. Issue notice to the contender opposite party. Requisites for issuance of notice by speed court with proof of delivery shall be filed by next week. Matter to be stated on 16th of December 2025. Yes.
Much obliged.
Item 6.
ನಮ್ಮ ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಸ್ಟಾಟಸ್ ರಿಪೋರ್ಟ್ ಆಸ್ತಿ
File the report, but this person wants some time to
instruction
verify
the record, verify the record. The election টা ছিল তো সে অফিসার মানে বিজি ছিল ইলেকশনে দেই না দিশা তো
So we are granting you want further time.
yes sir
You want to verify.
Yes,
yes sir
they have submitted.
Acha, the Learning Council for the petitioner seeks for an adjournment to obtain instruction on the later dated 28/10/2015 of the special LA and RRO LIIP Kharia, which was handed over to him by the Learning Council for the state. December of the 16th.
Item 7.
Item 7 and it already completed. 700 both are completed.
The Land Council for the state has produced the compliance guideline, which is taken on record. And accordingly, the content is closed. Same order in this item number 8. Yes, next.
Item 9.
Item 9 is also complied with.
Please pass.
Please copy. Okay.
Compliance order.
Madam, kindly see page 25.
Welcome.
Compliance order is given with this close. Yes, next.
Complied, madam. Complied.
Copy order division.
I guess.
Yes, the moment they join, you just intimate us. Those two IACs and the superintendent of police. Yeah.
Item 16.
Any there, madam. Item 10.
10.
Same.
Hmm.
My lords, there is the
Yes, that's
secretary home as a file letter.
Secretary Home was to a file affidavit.
Affidavit.
What happened?
There is two persons where they are one is dead and another is recaptured.
Where is the affidavit?
The reports list in the list that's what is
No, our order does not confine to that. There are so many queries made there.
thereafter we take the action against that.
Where is that? Where is your affidavit? Where is the affidavit of
Secretary
Home
Home
Secretary?
Department Government of Orissa file an affidavit.
It's a 13-page order.
No, that.
You come to page number 6 of that order. When we found, you got it?
Well,
That this appellant number 2 and 3, they have not been granted bail in this criminal appeal. We asked the Learning Council for the state to obtain specific instruction relating to appellant number 2 and 3 as to how they come to reside in their village when no bail order has been passed in respect of those two appellants. Then you produced the written instruction that is a letter from the Superintendent Biju Patnaik, Open Air Ashram Jamujhari, wherein you have stated that so far as appellant number 3 is concerned, he belongs to Bihar and he was admitted in that Pune jail and he was released for a prolonged leave from 25/3/2010 to 3/4/2010, maybe maximum 10 days. 10 days. Unfortunately, he has not surrendered and before the ashram authorities and several correspondence were made to the concerned IIC for taking necessary action. ये वाला appellant number 3 पाए. So far as appellant number 2 is concerned, it is found from the available record and register that he was the surety. ଗୋଟେ appellant ଆଉ ଗୋଟେ appellant ପାଇଁ surety ହଉଛି for the prolonged release, and it is not understood as to how the appellant number 2 was allowed to be a surety for appellant number 3, and if after the prolonged period has expired, the appellant number 3 did not surrender, what steps have been taken by the Viju Patnaik Opuniyar Ashram for his apprehension, and how appellant number 2 was released from this ashram. So we wanted a clarification on all these aspects. That is how we listed directed the matter. Then the matter was next come and we passed the order and then on 12/9/2025, one Smita Mohanty's affidavit with the superintendent that came wherein it is specifically mentioned that this appellant number 3 was admitted to so-and-so. He was released on prolonged leave for 10 days. Then he did not return and he has not surrendered. And appellant number 2 was also allowed as a surety. Surety bond and agreement copy has been annexed. However, in the affidavit, it has been mentioned that appellant number 2 was never admitted in Viju Patnaik Opuniyar Ashram. See. So if appellant number 2 was never admitted in the ashram, how could he be allowed to be a surety, particularly when he was a convict in the case? No explanation is forthcoming.
And both are in two different custodies.
The affidavit further reveals that in the agreement paper of prolonged leave, the address of the appellant number 3 has been given as village Konkada Jodi, PS Champua, District Keonjhar, though was a man from West Singhbhum in the state of Jharkhand. In paragraph number 5, it is mentioned that the messages were sent to OIC of Jagannathpur Police Station, West Singhbhum on different dates from 2010 to 2021 to make necessary arrangement of appellant number 3 to return to ashram since he has not surrendered after the period of prolonged leave, and message as well as letters have been annexed. In the affidavit, it is stated that one letter has been sent by the IIC Champua Police Station, which is addressed to the Advocate General, so and so, health condition, staying in his house, which is obviously in response to the order passed once. And accordingly, the ashram authorities requested the IIC Champua to take necessary steps to recapture appellant number 3. IIC Champua, in response to such letter, indicated that village of appellant number 3 does not come under Champua Police Station jurisdiction. It comes within Jagannathpur Police Station. Accordingly, the ashram authorities seem to have requested IIC Jagannathpur to recapture appellant number 3, but no response has been received. On perusal of the affidavit and order passed by it appears that everything has been done in a very casual way, and even though the appellant number 2.3 were life convicts and one life convict was allowed to go on prolonged leave on the affidavit count of the other, appellant number 2, and even though appellant number 2 was not staying in the ashram as per the affidavit. Another peculiar feature is how appellant number 2 is now staying in his village, even though he was neither granted bail by this court, nor has any record been produced before this court showing that he was either released prematurely or by way of leave or otherwise. if the release order of the appellant number is not available on record and the appellant number 3 has flouted the terms and condition of the prolonged leave and they are now residing in respective villages, it's not understood why no steps have been taken for recapturing them in accordance with law and why after later correspondence have been made right from 2010 till date. So the negligence of the jail authorities and IIS is apparent on the face of the record. Let the Secretary Home Department, Government of Odisha, file an affidavit as to what steps have been taken to ascertain how appellant number 2, in spite of not being released on bail, is now moving freely in his village and how appellant number 2 was allowed to be a surety for appellant number 3, why necessary steps to recapture appellant number 3 were not taken even though he had not been returned to Assam after availing the prolonged leave for 10 days, and what action has been taken against the hearing officials for giving misleading information to this court. Let us see your affidavit. Come to your affidavit. You take your seat, madam. Yes.
So far the appellant 2 is concerned below, there is the paragraph 8. Paragraph 8 I have stated that
we'll go one by one of that order. Come to the order.
yes, Mr.
The first we wanted to know from you what steps have been taken to ascertain how appellant number 2, in spite of not being released on bail by this court, is now moving freely in his village. This is number 1. Where have you mentioned? This is mentioned in page number 4. Come to that. Heading କରିଛି.
That these efforts have been undertaken in compliance with the objection of the Honorable Court. That in response to specific observation of Honorable Court regarding how appellant number 2 was allowed to act as juristic purpose.
Second aspect.
The first.
The first. You come to paragraph 5.
Madam.
This is in relation to what steps have been taken to ascertain how appellant number 2, in spite of not being released on bail by this court, is now moving freely in his village.
Paragraph 5.
Yes.
That upon a detailed examination of the report received from the Director General of Prison and Correctional Service Odisha and the Superintendent of District Jail Keonjhar, it is expected to submit that the administrative file pertaining to the sanction of the prolonged leave granted in 2003 to the life convict Jamdhar alias Jayapaksh Laguri, including the relevant approval order and connected correspondence, is not presently traceable either in the record of the District Jail Keonjhar or in the Director of Prison Odisha. This deficiency in the arrival of the record of keeping has confusion made it is difficult for the state government to produce the complete document evidence regarding the legal authorization under which the said furlough was a sanction. Pursuant to specific instruction issued by the Home Department for a comprehensive search of the missing record, it has however been a ascertained from the issue register of District Jail Keonjhar that VHA message and written communication were issued by the superintendent of the officer in charge Sampua Police Station Keonjhar and to the additional DG from IG prisoner and DCS Odisha, reporting the non-surrender of the said life convict after exercise of the furlough leave period.
No, this life convict has not been granted for long.
But
Life, who has been granted for long leave? He was appellant number 3.
He is granted.
Then
appellant number 2 ପାଇଁ କୌଣସି order ହିଁ ନାହିଁ, ତେଣୁ ଆପଣ ତାକୁ justify କରିବେ ସିଏ କେମିତି ଯାଇ ତା ଗାଁରେ ବୁଲୁଛି. What have you stated here?
My lord.
it is your own report that he is in the village.
He is there in
And
village.
then how you are saying that he is present? The document in respect to that is not traceable. He has not been sent on furlough. How can you get the document? He has not been released on bail, but how he is moving? That is our query. Then how you are again writing that you are searching for that document where the sanction order was passed?
Come to paragraph number 6 again. Let us see.
That the Honorable that the Home Department has completely and seriously acted upon the Honorable Court of Orissa regarding the unauthorized movement of the appellant number 2. Recognize the gravity of the situation. The matter was placed under the continuance and close supervision at the senior administrative level, involving the coordinator monitoring the Home Department, the Director of Prisoner and Superintendent of Police Keonjhar. Pursuant to this high-level intervention, urgent and repeated direction was issued on such and such letter such and such to the Superintendent of Police, West Singhbhumi, Jharkhand, and the concerned inspector in charge for the immediate recapture of the fugitive based on his verified presence at village Tondawood, PS Jagannathpur district, West Singhbhumi, Jharkhand. Copy of the Home Department letter such and such and the letter such and such. The answer C and D respectively. That paragraph 9 minutes.
Come to paragraph 7.
That in continuance of this instruction and under the active follow-up at the senior level, the Superintendent District Jail Keonjhar lodged an FIR before the IIC Keonjhar Town Case number
Bigger laws
leading to the registration of Town Case number
12,
and section acting on the FIR and subsequently instruction the Keonjhar Town Police recaptured the appellant 2 from the village such and such, producing before the London District of Keonjhar on 13/11/25 was remanded in the jail judicial custody.
No, did you ask him how you went out?
Yes, against that the proceeding has initiated and
କଣ ପଚାରିବାକୁ ଚାହୁଁଛୁ ଆମେ ବୁଝନ୍ତୁ. ଆପେଲାଣ୍ଟ ନମ୍ବର 2 କୁ ପଚରା ଗଲା କି ଯେ ବାବୁ ତମକୁ ତ ବେଲ ଯାଇନି, ଜେଲରୁ ବି ଆମେ ଫୋରଲଙ୍ଗ ରିଭରେ ଛାଡି ନଥିଲୁ, ତମେ ଗାଁରେ କେମିତି ଯାଇ ବୁଲିଲ, କୋଉ ବାଟରେ ଜେଲରୁ ଖସି ପଳେଇଲା ନା କେମିତି ଗଲା ସେ ବିଷୟରେ କି ଜାଣିଲେଣି? ଆପେଲାଣ୍ଟ ନମ୍ବର 2 କି ଏଟା ତ ହଉଛି ଆପଣଙ୍କ ପ୍ରଥମ ଡ୍ୟୁଟି ନା ପଚାରିବାକୁ ଯେ କୋଉ ବେସିସରେ ତୁ ଆସି ଗାଁରେ ବୁଲୁଛୁ. ହାଇକୋର୍ଟରୁ ତ ବେଲ ହେଇନି, ହାଇକୋର୍ଟରେ ଆପିଲ ପେଣ୍ଡିଂ ଅଛି ହେଲା, ତୁ ତ ମାନେ ତତେ ଛଡା ହେଇନି, ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ହେଇନି, ପ୍ରୋଲଙ୍ଗ ରିଭ୍ୟୁର କିଛି ଡକୁମେଣ୍ଟ ନାହିଁ, ତୁ ଆସି ଗାଁରେ କେମିତି ପହଞ୍ଚି ବୁଲୁଛୁ? କଣ ଏଗୁଡାକ ସବୁ କହିବାକୁ ପଡିବ ଆପଣଙ୍କୁ? କଣ ଆପଣ ତାକୁ ପଚାରିଲେ, କଣ ସେ କହିଲା କଣ? Because it would expose the jail authorities activities. ସେଠି ସେ ପୁନେୟାର ଆଶ୍ରମରେ 42ଟା ଖସି ପଳେଇଛନ୍ତି. ହଁ, this is how you are looking on these matters. These are all live convicts. Where is he now? This appellant number 2
in custody.
No, custody ମାନେ କୋଉ ଜେଲ? କେଉଁ ଜେଲ ତାକୁ କୁହନ୍ତୁ ହାଜର କରିବେ. Next ପଢନ୍ତୁ.
Paragraph 8 that the following recapture the Superintendent of District Jail Keonjhar has submitted a detailed factual report of the Director of Prison outlining the circumstances of the arrest, the police coordination involved in the updated custody status of the said live convicts. Copy of the detailed factual report furnished by the Superintendent of District Jail Keonjhar flag G. That those actions have been undertaken in the continuance of the direction issued and in the compliance of the observation of the Honorable Court.
Okay, now this is so far as appellant number 2 is concerned. Next two is that how the appellant number 2 was allowed to be a surety for appellant number 3. କାରଣ appellant number 2 କୁ ଆପଣଙ୍କ ରେକର୍ଡ କହୁଛି ସିଏ କେବେ ଯାଇନି ବିଜୁ ପଟ୍ଟନାୟକ, ସେ ତାକୁ କେମିତି surety କଲେ?
That is the
Wrong
para
question.
10. That in response to the specific observation of the Honorable Court regarding the how the appellant 2 was allowed to act surety to the appellant number 3, and why necessary steps were not taken to recapture all the appellant number 3, despite the no return after the availing solo leave. It is respectfully and timely submit that the matter was thoroughly and independently inquired into the Deputy Inspector General, Prison, Cuttack, Range Cuttack, personal specific direction of the Honorable Home Department. Of the inquiry report submitted in the Deputy Inspector what is the answer is under the paragraph 11 that as per the finding of the said inquiry, the record of Bijupatna Air Ashram Jammu revealed that name of the appellant number 2, Joyprakash Laguru, was not originally mentioned as a surety in the prologue application form F of the appellant number 3, Nanu Naresh Laguri. Instead, another individual named Janda Laguri was recorded as a surety. However, in the surety bond, which was executed on the plain paper and not in the prescribed format, this name of the surety are merely written without their physical appearance or signature. In that list, the name of the Jamda Joyprakash Laguri is also written along with the actual surety lent Janda Laguri. Copy of the prologue application that earlier also the Bijupatna Superintendent of Bijupatna Air Affairs filed there. Paragraph 12. That in the inquiry further found that the then Superintendent Vijay Kumar Paikara filed to ensure a compliance failed to ensure a compliance with the establishment of procedural
failed to ensure compliance with established procedural
safeguard prior to the
release
release of the convict on the prologue.
There is
It has also been established that the said superintendent had no available record or source of information at the time of ascertaining the appellant number 2 was already a prologue absconder from the district jail Keonjhar since 2003. The said lapse have since been duly noted and the matter has been examined for the appropriate administration action.
ଓ ସିଏ ତାମାନେ କହୁଛନ୍ତି ସିଏ ଯୋଉ 2 ନମ୍ବର ବି ଫୋରଲଙ୍ଗ ରେ ଯାଇକିନି ଆବସ୍କଣ୍ଡିଂ କରୁଥିଲା ତାକୁ ଆଲାଉ କରାଗଲା ଆଉ ଜଣକୁ ନବା ପାଇଁ ଫୋରଲଙ୍ଗ ରେ ସିକ୍ୟୁରିଟି
that with regard to the step taken for the recapture of the appellant 3, it is emphatically submitted that action was taken immediately after his failure to the surrender on 3/4/2010. The Superintendent of Bijupatna Open Air Ashram Jammu issued a double T message number FPK of the office in the charge Jagannathpur Police Station, West Singh, Jharkhand, followed by the series of letter and a wireless message over the year from 2010 to 2025 to concerned police station, Sampua, Jhampura and Jagannathpur, and to the Superintendent of Police Keonjhar, urging the immediate tracing and recapture the absconding live convict. Copy of the communication made by the Superintendent of Open Ashram to the concerned police station, that is the J series, that is Mr. J series. That despite persistent communication from the jail authority, no substantive response was received from the local police authority over the extended period. The IIC Champa Police Station by letter confirmed in this letter dated 16/7/25 that appellant 2 and 3 were residing in their native village Tadaganda PS Jagannathpur district West Singhbhumi, Jharkhand. On receipt of this confirmation, renewed directive were issued by the Superintendent of Bijupatna Open Air Ashram, double T message number such and such, and letter number such and such to the Superintendent of Police Keonjhar and to IIC Jagannathpur PS for his immediate recapture. Copy of the IIC Champa Police Station, that is the answer K, and copy of the double T message, that is the L series mirror. Then the paragraph 15 mirror, that in response to the IIC Jagannathpur PS by letter dated 30/25 informed that the appellant number 3 has expired on 17/8/25. But that is the report given by the concerned IIC Jagannathpur, but not in the written in the locality. That is the answer end.
Death certificate.
Where is the death certificate?
The death certificate has not been received, but there are the IIC has given that.
We can't believe anymore.
So on that respect, we can produce the.
What type of stance time to time you are taking? And to save whom? These hearing officials. ଜଣେ accused prolonged leave ରେ ଯାଇକିନି ତା ଗାଁରେ ରହୁଛି, ଆପଣ ଆକୁ ତାକୁ ଚିଠି ଲେଖୁଛନ୍ତି, you have got no power. Suppose a accused was committed under the jurisdiction of Lalbagh police station. He is now staying in Baleshwar. This IIC Lalbagh police station cannot go there and take steps to arrest him. It is necessary that he should write a letter to Baleshwar and he will arrest and produce him. What sort of this is CRPC unheard of. If you want to carry out an investigation or to arrest a person, the procedure is laid down in the CRPC police manual, that you are to just go to that police station under whose jurisdiction that person, intimate him, and a police official would go, one of the officials from that local officer, he would go and execute it, and again that will be intimated to the concerned police station, and then that will be brought in, and if it is a long distance, it will be produced before the nearest magistrate, that 24 hours, then it will be brought and produced in the appropriate court. That is the procedure. ଆକୁ ଚିଠି ଲେଖୁଛନ୍ତି, ତାକୁ ଚିଠି ଲେଖୁଛନ୍ତି, ସିଏ ଯାଇ ବୁଲୁଛି 15 ବର୍ଷ ହେଲାଣି.
And see, all these actions have been initiated only after our order is passed.
Yes,
That means these are all stage managed.
they are not.
These are all stage managed.
That is the reason why they stated that 40 odd persons are absconding, live convicts are absconding from that Biju Patnaik Upar jail. 47.
And so for the death person is concerned, we will also talk about that.
No, you cannot believe unless you produce it, you
the
cannot
death
believe.
certificate or report from the concerned locality.
Your IIC is giving report in another case that they are dead, even though they are alive, and we would have closed the criminal proceeding, that it is abated.
And, on that respect, to produce that report, authenticated report also.
Yes, what action you have taken? Come to paragraph 17.
That with regard to the observation of the Honorable Court concerning the punishing of the misleading of information by the prison authority, it is respectfully submitted that the said observation dependent to the status report dated 25/7/25 submitted by the district jail Keonjhar, which has incorrectly stated that no further information is available regarding app number 2 after 98, despite judicial record establishing his continuance custody following conviction. That in immediate compliance with the Honorable Court direction, the Director General of Prison and Correctional Service Odisha ordered to a formal inquiry to ascertain the responsibility of the lapse. The inquiry is conducted by the Deputy Inspector General Prison Kotak Range Kotak and the Senior Superintendent Secretary such and such, copy of the DG Prison Letter such and such, and a copy of the inquiry report submitted by the Deputy Inspector General Prison is the Anster O. On the basis of the finding of the said inquiry, 2 official district jail Keonjhar were identified, and the response for the preparation and submission of the misleading report to the Honorable Court, namely Sri Upendra Kumar Jana, district jail Keonjhar, and
Deepak Kumar
Samantre, assistant jailer for district jail Keonjhar. That consequence upon the inquiry finding, the Director General of Prison and Correctional Service has initiated disciplinary proceeding for major punishment against both the officers. This prompt and decisive action demonstrated the government firm resolved to ensure administrative accountability and transparency in all matters of judicial reporting.
So, did you send information to that?
Yes, I'll call the jailer.
Yes, now, which matter we are keeping this matter, we call him and pass order. Which matter the
Item 3.
Item number 3.
The SP Malkanagiri is on brief.
Jadi itu pun aku dapat. Item number 0. Do that. Then but what problem? One consent. Silence. Yes. Yes, sir. Call the
Please
SP
join.
to join.
Please join.
Ask him to open the.
SP Malkanagiri, please join.
Jain sir.
Mr. Superintendent of Police, I think that you have gone through the orders which you have passed in this case. This is criminal appeal number 461 of 2012, in which there are two appellants. One is Sanjeet alias Sanjeev Mandal. The other is Amela Barawi alias Mandal, and they are the husband and wife. They have been sentenced to life imprisonment by the London Trial Court, and they have been directed to be released on bail. And now the matter has come for hearing, and when we the counsel who is appearing for them intimated us that when we asked about the well-being, he said that we are not aware. Then we passed different orders. Now, what we find that the one report was submitted on us before us by the IIC Model Police Station, and he is present here and standing before you also. He stated that he is in as the IIC since 2023, and he submitted this report on 8/5/2025 that the appellants, both the appellants, are alive. Then he submitted another report which is dated 27/10/25, wherein he indicated that both the appellants are dead since 10 years. So the two reports submitted by this IIC Rizal Kindo were quite contradictory to each other, because in May report he is telling that they are alive, and October report is telling that they died 10 years back. So we asked to him to hold an inquiry and submit a fresh report, and we also directed you as the superintendent of police to monitor the inquiry. Now today he has submitted an affidavit wherein he has stated that after getting this order of this court, he deputed one Prithivas Behra, who is the sub-inspector of police, Malkangiri, and that sub-inspector collected written information from the villagers and ward member, and he submitted the report that both the appellants are dead since 10 years back, which is, according to him, is not correct, because they are alive when he inquired him personally. So we asked him that when such a misleading report has been given to us about the death, we could have, if we had trusted him, we would have said that the appeal abates because of the death of the appellants and what action has been taken. He said that I sought for an explanation from that sub-inspector, and he has given that explanation, begging apology. So that is how the situation stands now. So, Mr. SP, what have you done in this matter?
Sir Jain sir. Sir, this matter has come to my knowledge only recently. So necessary action will be taken, sir, in this matter.
No, recently.
So only when the personal appearance was called for IAC, that came into my knowledge. So this contradictory report, this will be inquired into, sir, and necessary action will be taken against.
No, this IIC
Sir.
is authorized to take any disciplinary action against a sub-inspector.
Sir, explanation can be called for, sir.
No. Has he intimated you that he has called for an explanation under whether he can issue suo moto, or at your instance, after communicating you, the explanation would have been called for, because in view of this factual scenario when misleading reports are given and it is within your knowledge.
So suo moto explanation can be given, sir.
Yeah. And then he will sit over the matter. After getting the explanation, he is the authority to decide that when action is to be taken or not, even though he has flouted he has submitted a wrong report to this court. This IIC is to decide whether action is to be taken. That is your interpretation.
No, sir. It further should be communicated to SP if the explanation is not satisfied.
That means this order dated 11/11/25 has never reached you.
It has just reached me, sir.
You have never monitored any matter regarding this inquiry? The report has been called for. Is the report with you?
No, sir. This matter has not reached me. There must be some communication gap, sir.
Gap? Communication gap between
Sir,
SP and sub-inspector?
We have specifically directed, and that is mentioned in page number 2 of the order, that the IIC Model Police Station Malkangiri was to conduct a proper inquiry and submit a fresh report relating to the present status of both the appellants, and also directed the Superintendent of Police Malkangiri to monitor the inquiry. That is the a thing, and we have also given a free copy of the order to the Land and Council for the state to comply. That means the state council is duty bound also to communicate you that this is the order passed, and apart from that, IIC also.
Sir.
Have you communicated
Yes,
the order?
from 17/11.
The state council here submitted that the order has been communicated to you on 17th of this month, and you say
Sir.
that you have not received the copy of the order.
Sir, perhaps, sir, since I was away from the headquarter Malkangiri for the conference to Bhubaneswar, there must be oversight from my side, sir. I did not receive any DAC. So the matter will be inquired on priority basis, and necessary action will be taken from our end, sir.
We are posting this case on 2nd of December 2025, and you go through this different order passed by this court, particularly the order which you have passed on 11/11/2025, and the affidavit which has been produced before us or filed before us by the IIC Malkangiri police station, and apprise us that what you are doing in this respect, and what action has been taken against whosoever is aid in this regard. Maybe it is Krutivas Behra, the sub-inspector, or it is Regan Kindo, the IIC Malkangiri Model Police Station himself.
Sir.
So whosoever, what action you are taking, and why this thing has happened. So all these things you personally submit a report before us by the next date.
Noted, sir.
What is the name of the superintendent of police?
Vinod
Yes.
Patil.
Vinod Patil. Vinod Patil.
Vinod Patil.
Patil.
Give the name in writing. You come to the front. As for the order dated 11/11/2025, Sri Regal Kindo, Inspector in charge of Malkangiri Model Police Station, has appeared before us personally, in person. Yes, we made a query to him, and he told to us that he is working as IIC in Malkangiri Model Police Station since Kebet Royjandi?
2002.
Bebe ma kung maso?
Kebet Roylen ako.
Kung maso Roylen? 2023 ro.
January.
January. Since January 2023. In the affidavit filed by him, he has stated that when we called for a further report in this case relating to the status of both the appellants, that is Sanjeet alias Sanjeev Mandal and Amela Baroi alias Mandal, he deputed one Kutivas Behra, Sub-Inspector of Police, Malkangiri, to the native village of the appellants to inquire and to report about the status. And the said Sub-Inspector visited the village, collected written information from the villagers as well as ward member of MPV-03 Gram Panchayat, and since the whereabouts of the appellants were not known for 25 to 30 years, as they were not coming to the native village, accordingly, the report was submitted to the Office of the Land and Advocate General on 2010-2025, indicating that the appellants have died since 10 years back. He has further stated that after passing of the order dated 11/11/2025, he personally inquired into the matter in the native village of the appellants, and it is brought to his knowledge that both the appellants are alive, and they are residing in a thatched house, and the appellant number 1 is working as a helper in a trough, and appellant number 2 is a daily wage laborer, and both of them used to go to Andhra Pradesh and Bangalore for their livelihood. He further stated in the affidavit that the report which was submitted by the Sub-Inspector Kuttivas Behera before him was a misconception report regarding the death of the appellants, which was neither intentional nor deliberate. Where have you stated that you called for an explanation from him?
That document was not with him, that's why that has.
No, no, averment taken?
No.
Acha.
That document could not.
When we made a query to the IIC as to whether any action has been taken against Sub-Inspector Kuttivas Behera for giving such a report, false report regarding the death of both the appellants before him, which was forwarded to the London Advocate General's office and placed before this court. He stated that an explanation was called for from the Sub-Inspector Kuttivas Behera, and it has been received by him, but no further action has been taken. In view of such a state of affair, since as per the order dated 11/11/2025, we had directed the IIC to hold proper inquiry and to submit a fresh report relating to the present status of both the appellants, and also directed the Superintendent of Police Malkangiri to monitor the inquiry. We thought it proper to ensure the appearance of the Superintendent of Police Malkangiri virtually. And accordingly, so and so, the SP Malkangiri appeared before us. And he stated that till now he is not aware about the order passed in 11/11/2025, nor he has received the copy of the order dated 11/11/2025. Though in the very order we had asked, we had directed that the free copy of the order is to be handed over to the London Council for the state for compliance. Most importantly, the London Council for the state submitted before us that the order dated 11/11/2025 has been communicated to the Superintendent of Police Malkangiri on 17/11/2025. The Superintendent of Police submitted that since he is now aware about the order passed by this court and the gravity of the matter, he will inquire into the matter personally and will go through the affidavit which has been filed by the IIC Malkangiri Model Police Station before this court today and submit a report regarding any disciplinary action to be taken against any erring police officials for submitting such misleading report. Put up this matter on 2nd of December 2025. The IIC Model Police Station shall remain present before this court physically, and the Superintendent of Police shall appear virtually on that day, and the matter will be taken up at 10:30 a.m. Free copy of the order be handed over to the Land Council for the state, and on that day, the IIC shall also ensure the appearance of both the appellants, that is Sanjit Swanso and Amela, through virtual mode. Free copy of the order be handed over. Yes. Next. The personal appearance in Swanso for dispensary for today. Yes. Next.
Yeah, sir.
Yes.
Number.
Item.
11, 10.
Item 2. ଆପଣଙ୍କ ନାଁ କ'ଣ ଅଛି?
Let us see that what was there.
ଆପଣ IIC ବରପାଲି ନା?
Banaigarh. No, but she is from Kevlar jail, like it is mentioned. Kindly on
Arata case. It appellant has been released from case. This is jail item number 2 to.
IIC କୋଉଠି କହୁଥିଲେ? ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ। କୁହନ୍ତୁ ଆପଣଙ୍କ ନାଁ, ଆପଣ କୋଉଠି କହୁଛନ୍ତି?
ସାର୍ ନମସ୍କାର, ଜୟରଶ୍ମି ମୁଁ ଆଇଆଇସି ବରପାଲି କହୁଥିଲି, ବରଗଡ଼ ଡିଷ୍ଟ୍ରିକ୍ଟରୁ ସାର୍।
Item 1.
Item
1.
1.
Item number 1 is number 3.
Oh, did not. Okay. Yes, Superintendent and Professor Master were doing from IAC since 2009. September 2025, matter is pending.
So, madam, ଆପଣ ଏଇ ଯୋଉ ବରପାଲି ଥାନାର IIC ହିସାବରେ କେବେଠୁ ଦାୟିତ୍ୱ ନେଲେଣି?
ସାର୍
କେବେଠୁ ନେଲେଣି ନା ସାର୍?
ସାର୍ 2023ରୁ ସାର୍ ଅଛି।
ଆପଣ ଏଇ କେସ୍ ସଂକ୍ରାନ୍ତରେ କିଛି କମ୍ୟୁନିକେସନ ପାଇଛନ୍ତି ଆଡଭୋକେଟ ଜେନେରାଲ ଅଫିସରୁ? ଏଇ ପଙ୍କଜ ଭୋଇ ଯିଏକି ଆମର ଏଡିସନାଲ ସେସନ ଜଜ୍ ବରଗଡ଼ଙ୍କ କୋର୍ଟରେ 302, 376 G 201/34 ଦଫାରେ ସେ ଟ୍ରାଏଲ ଫେସ୍ କଲା ଏବଂ 22/2/2007 ତାକୁ ଜଜମେଣ୍ଟ ତାର ସେଇ କେସରେ ହେଲା ଏବଂ ଲଣ୍ଡନ ଟ୍ରାଏଲ କୋର୍ଟ ତାକୁ 302 ଦଫାରେ ଆଜୀବନ କାରାଦଣ୍ଡ କରିଛନ୍ତି ଆଉ 376 ରେ 10 ବର୍ଷ କାରାଦଣ୍ଡ ଦେଇଛନ୍ତି ଆଉ 201 ରେ 3 ବର୍ଷ କାରାଦଣ୍ଡ ଦେଇଛନ୍ତି। ତ ଯାହା ଜଣା ପଡୁଛି ଯେ when he was granted bail, acha 8/7/2011 8/7/2011 ରେ ତାକୁ ବେଲ୍ ଅର୍ଡର ତାର ହେଇଛି। ବର୍ତ୍ତମାନ ଏ କେସ୍ ବିଚାର ପାଇଁ ଆସିଗଲାଣି।
ସାର୍
ତେଣୁ ସେ ଯେହେତୁ ତାଙ୍କ ଓକିଲଙ୍କ ସାଙ୍ଗରେ ଯୋଗାଯୋଗ କରୁନି, ତେଣୁ ଆମେ ଜାଣିବାକୁ ଚାହିଁଥିଲୁ ଯେ ତାର ୱେଲବିଂ କଣ। ତେଣୁ ଷ୍ଟେଟ କାଉନସିଲ ଚିଠି ଲେଖିଥିଲେ ଏବଂ ଏ ସଂକ୍ରାନ୍ତରେ ଜେଲରୁ ଓଭିୟସଲି ରିପୋର୍ଟ ଆସିଛି ଯେ ସିଏ ବେଲରେ ଅଛି ବୋଲି।
ସାର୍
ତେଣୁ ବର୍ତ୍ତମାନ ବେଲରେ ଅଛି ବୋଲି ଲେଖିଛନ୍ତି ନା।
Yes.
ଆଣ୍ଡ ଆପଣଙ୍କୁ ରିପୋର୍ଟ ସିଏ ଲେଖିଥିଲେ ଯେ ମାଗିଥିଲେ ଯେ ତାର ସେ ବଞ୍ଚିଛି କି ମଲାଣି ଏ ବିଷୟରେ ତାର ୱେଲବିଂ ରିପୋର୍ଟଟେ ଦବା ପାଇଁ। ସୋ
ସାର୍
ଏପର୍ଯ୍ୟନ୍ତ ଆପଣ କିଛି କଲେଣି ଏ ବିଷୟରେ? ପଙ୍କଜ ଭୁଇ
ସେ ୱାନ୍ ମନ୍ଥ ହେଇଗଲାନି ସେ ସାର୍ ଡେଥ୍ ହେଇଗଲାନି ସାର୍। ଏଇଟା ରିପୋର୍ଟଟା ମୁଁ ପଠେଇଦେବି ସାର୍।
ପଠେଇ ଦେବେ ନା ପଠେଇ ଦେଲେଣି?
ସାର୍ ଏଇଟାକ କାଲି ଲେଖିକି ନେଇ ଆସିଛି ତାଙ୍କୁ ଇନକ୍ୱାରି କରିକି ସାର୍ ରହିଯାଇଥିଲା ଏଇଟାକ ମୁଁ ଆଜି ହିଁ ପଠେଇଦେବି ସାର୍। ଏବେ
ତାର ଡେଥ୍ ସାର୍ଟିଫିକେଟ ପାଇଲେ?
ଡେଥ୍ ସାର୍ଟିଫିକେଟ ତାଙ୍କ ଘରେ ନଥିଲା, ହେଇନଥିଲା ବୋଲି କହିଲେ ସାର୍।
କୋଉ
ଆଉ ମୁଁ
ବେସିସ ରେ
ସେଥିପାଇଁ
ଆପଣ ମାନେ କାହାକୁ ଏକ୍ସାମିନ କରି ନା କେମିତି ସରପଞ୍ଚ କରିବା ଅଥେଣ୍ଟିକ
ନାଇଁ
ରିପୋର୍ଟ?
ସରପଞ୍ଚକୁ ଆଉ ତାଙ୍କ ଘରକୁ ମୁଁ ଯାଇଥିଲି ସାର୍, ନିଜେ ଯାଇଥିଲି ସାର୍। ଆଉ ବୁଝିକି ଆସିଛି, ସେ କହିଲେ 1 ମନ୍ଥ ହେଇଗଲା ଇଏ ହେଇଛି, ଆଉ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଆମର ବାହାରି ପାରିନି ବୋଲି କହୁଥିଲେ ସାର୍।
So you submit a report on the basis of the which
ସାର୍
inquiry you have
ଆଜି
committed. So
ସାର୍ ଆଜି ମୁଁ ପଠେଇଦେବି ଏବେ ସାର୍।
acha we are then ଆପଣ ଯଦି ଆଜି ପଠେଇବେ, ଆଜି ହଉଛି ଗୁରୁବାର, ଆମେ ଏଇଟା ଆସନ୍ତା ଗୁରୁବାରକୁ ରଖୁଛୁ
ସାର୍
27th କୁ। ତା ଭିତରେ ଷ୍ଟେଟ କୁ ରିପୋର୍ଟ ପଠେଇ ଦିଅନ୍ତୁ ଆପଣ
ସାର୍
ଏଜି
ସାର୍
ଅଫିସ କୁ, ହେଲା?
ଆଜ୍ଞା ସାର୍ ସାର୍।
So if the death report has not been obtained, at least the death report must have been entered in the this is before the birth and death or with sarpanch?
ସାର୍ ସାର୍
With sarpanch.
ସାର୍ ତାଙ୍କ ଘର ଫ୍ୟାମିଲି ମେମ୍ବର୍ସକୁ ଆଉ ତାଙ୍କ ପାଖ ପଡିଶା ଘରକୁ ବୁଝିଥିଲୁ ସାର୍ ଆମେ।
ଆପଣ ଆପଣ ସବୁ କଥାରେ ଏତେ ବିଶ୍ୱାସ କରି ଯାଆନ୍ତୁନି। ତ ତାଙ୍କ ଘର ଲୋକ କହିଦେଲେ ସେ ମରିଗଲାଣି ବା ପାଖ ପଡିଶା କଣ କହିଦେଲେ, ଆପଣ ଯୋଉ ଅଥେଣ୍ଟିକ ରିପୋର୍ଟ ଦବା କଥା ଆପଣଙ୍କର ଗ୍ରାମ, ଆମେ ସେଇଥିପାଇଁ ଆମେ ସରପଞ୍ଚ କୁ କହୁଛୁ। ଆପଣ ସରପଞ୍ଚ ତାଙ୍କର ଏଣ୍ଟ୍ରି ହଉଥିବ କି ଯୋଉ ବାର୍ଥ ଆଣ୍ଡ ଡେଥ୍ ରେଜିଷ୍ଟର ଆଜିକାଲି ମ୍ୟାଣ୍ଡେଟୋରୀ ଯୋଉ ଅଛି ଗଭର୍ଣମେଣ୍ଟ ରେଜିଷ୍ଟରରେ ଯଦି କିଛି ଏଣ୍ଟ୍ରି ହେଇଥିବ, ସେ ବିଷୟରେ ଦେଖନ୍ତୁ ଏବଂ ତାରି ବେସିସ ରେ ରିପୋର୍ଟ ଦିଅନ୍ତୁ।
ସାର୍ ସାର୍
ତ ଫ୍ୟୁଚରରେ ଆପଣ ଯେମିତି କିଛି no problem is faced by you, ହେଲା?
ସାର୍
କାରଣ
ସାର୍ ସାର୍
ଆଜିକାଲି ରିପୋର୍ଟ ବି ଦିଆ ହେଇଯାଉଛି, ଆଇଆଇସି ମାନେ ରିପୋର୍ଟ ଦେଇ ଦଉଛନ୍ତି ଡେଥ୍ ହେଇଗଲାଣି, ଦେଖିଲା ବେଳକୁ ପୁଣି ଆଉ ଗୋଟେ ରିପୋର୍ଟ ଦଉଛନ୍ତି ନାଇଁ ସେମାନେ ବଞ୍ଚିଛନ୍ତି। ତେଣୁ
ସାର୍ ମୁଁ ସରପଞ୍ଚଙ୍କଠୁ ଆଉ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ତାଙ୍କର
ଯାହା କରିବା କଥା ଲିଗାଲି
ସାର୍
ଯୋଉଟା ଇଏ କରନ୍ତୁ, ଯୋଉଟା କି ଗୋଟେ ରିପୋର୍ଟଟା ଯେତେବେଳେ ଦଉଛନ୍ତି ପରଫେକ୍ଟ ରିପୋର୍ଟ ସୁଡ୍ କମ୍ ଇନ୍ ଆକର୍ଡାନ୍ସ ୱିଥ୍ ଲ, ହେଲା?
ସାର୍ ସାର୍ ସାର୍
ଆଚ୍ଛା, ତାଙ୍କର ନାଁଟା ଦିଅନ୍ତୁ ଆପଣ ଲେଖିକି। ମ୍ୟାଡାମ ଆପଣଙ୍କ ନାଁ କଣ?
ଜୟରଶ୍ମି ସେଠୀ।
Rashmi Sethi.
ଲେଖନ୍ତୁ ଜୟରଶ୍ମି ସେଠୀ, the
Sir.
inspector in charge of Barpali police station, appears through virtual mode, and she submits that she is acting as the IAC of the said police station since 2023. She further submits that after receipt of the communication from the AG office, she personally inquired into the matter owing to the release of the appellant and came to know that the appellant died since a month back. And she will submit a report to the AG office during course of this week. Hello? This matter on 27th of November 2025. the London Council for the State shall place the report on the said date, है ना? 27 तारीख रे मैडम हमें रखिलु आपण से दिन रिपोर्ट देबे, है ना?
सर
Yes.
सर
This is
Keonjhar
Who matter ना?
item 10.
Item 10 पर. Kuda barabar. Eta hoji. Eta.
item 10. ଗୋଟେ ହୋମ ସେକ୍ରେଟାରୀ ଯୋଉଟା ଫାଇଲ କରିଥିଲା
तो ना कौन आपका नंबर 2 जमादार उर्फ जयप्रकाश लगुरी से लोक सामना को आणंतु ओ तुम ना कौन बढ़िया बुझी परचो
थोड़ा थोड़ा समझते हैं सर।
हाँ कौन बोलते
आपका नाम क्या है
जमदार लागोरे जयप्रकाश लागोरे।
अच्छा और ये जो दूसरा आदमी है जो नानू नरेश लागुरी उसका क्या हुआ
मर गया सर।
कब मर गया
अभी 1.5 साल हो गया सर।
1.5 साल हो गए
जी
ये जो तुमको जो सजा दिया है और ये हाई कोर्ट से तो तुम बेल से नहीं गए थे और गांव में जाकर कैसे घूमे कैसे
सर,
तुम बाहर गए जेल से
सर पागल हो गया सर। यहाँ से चोटी से गए थे, पागल हो गया तो आ नहीं पाए।
फॉरलॉन्ग लीव में कितने दिन के लिए गए थे
15 दिन के लिए गए थे सर।
हाँ
15 दिन के लिए
15 दिन कब गए थे कौन सी साल में
सर वो तो हमको याद नहीं है सर।
अच्छा वो 15 दिन के बाद आप वापस नहीं आए
सर मैं पागल हो गया तो आ नहीं पाए।
क्या हुआ
पागल हो गए थे
पागल हो गया था
कहाँ एडमिट था
जी एडमिट नहीं था सर, मैं इधर उधर भटकते रहते थे।
इधर उधर भटक रहा था अच्छा और आपने आके वो जो दूसरा वाला जो मर गया उसको सिक्योरिटी में ले गया आपका उस वक्त आपका हालत ठीक था उस वक्त भी आप मतलब पोलोंग रीव में जाके आपने जेल को नहीं वापस आया दूसरा जेल में वो जो जामुजरी में जाके वो दस्तखत करके उसको भी ले गया साथ में उसको भी लीव में ले गया
जी सर वो तो मेरे साथ नहीं गया था।
आपको पता है आपको लाइफ सेंटेंस हुआ है आजीवन कारादंड
सर मालूम नहीं है।
आपने आपका वकील के साथ बातचीत की कौन सी वकील आपका है आपको पता है कौन सी वकील आपने दिए हैं केस में
जी जत्रमाई छोड़ोगे तो सर।
कौन सी
किनको
जत्रमाई छोड़ोगे
सड़ंगी
ये रिकॉर्ड के हिसाब के आपकी वकील का नाम है आचार्य AK आचार्य अरुण कुमार आचार्य
ये जिनका नाम आप बता रहे हैं ये कहाँ के हैं
जी ये केंजर के हैं सर।
क्योंजर का है
क्योंजर के हैं
तो वो
जी।
ला के दिया लोकल आर्डर हुई आप आपके जो अभी वकील जो है जो आपकी केस अभी करेंगे हाई कोर्ट में
जी
अभी आपकी केस को ये हियरिंग होगा तो आप उनके साथ अगर बातचीत करना चाहते हैं तो ये फैसिलिटी आपको अवेलेबल किया जाएगा वो अगर कुछ जानना चाहते हैं केस के बारे में आपको पूछेंगे क्योंकि उनका कहना है कि वो खत लिखते हैं आपके पास और कोई भी रेस्पॉन्स आप नहीं देते हैं, तो इसीलिए जो एड्रेस है उनके वो बताते हैं थे हमको कुछ अभी पता नहीं, तो उनके साथ अगर आप बातचीत करना चाहेंगे तो आप बात कर सकती है। और
जी
उनको पता नहीं आप उनको जानते कि नहीं, क्योंकि आपने शायद वो लोकल एडवोकेट को दिया है और लोकल एडवोकेट ने इनको एंगेज किया है, वो
जी
जो आचार्य साहब है।
जी
तो बातचीत करना चाहेंगे आपको आप?
जी सर बात करना चाहते हैं।
अच्छा ठीक है, तो please arrange that
Contact number we can say.
contact number.
I have contact number.
To just give the contact number to that
Yes.
superintendent, so that either virtually you will talk to Mr. Acharya, okay, and date and time to be fixed, and whatever information he wants to take, we can take up this matter now in view of this report. And so far as this, see, though he has also stated that he is dead, but we ask you to produce that death certificate.
So that's why the page 86 that IAS we can produce that saying that the मृत्यु का प्रमाण पत्र then
जो गाँ रे आमे बुझा बुझी कलु से मरी जाइछि सेगुडाक वर्तमान देखुचंदी कोन होउछि सिचुएशन, डोंट एक्सेप्ट इट। से गाँ लोक कोन कहि देले मृत्यु हेइ जाइछि ताकू ये करंतुनी, मृत्यु की प्रमाण पत्र आणंतु बा जोठी ऑथेंटिक रिपोर्ट अछि, कारण इट्स ए रजिस्ट्रेशन इज मैंडेटरी, सो इट इज द ड्यूटी ऑफ द that sarpanch communicate to the and make mention in the necessary government record, so it will form a part and parcel of the government record. Every death and every birth is to be registered in accordance with law. देखंतु एटा कि
item 10
item number 10 de lakhon. As for the order dated 16/9/2025, the additional chief secretary to government, Home Department, Government of Orissa, has filed the compliance affidavit. A reading of the said affidavit, in the aforesaid order, we have asked to file the affidavit on the following aspect. Roman 1, what steps have been taken to ascertain how appellant number 2 Jamadar alias Jayaprakash Laguri, in spite of not being released on bail by this court, is now moving freely in his village. Roman 2, how appellant number 2 was allowed to be a surety for appellant number 3, Nanu alias Naresh Laguri. Roman 3, why necessary steps to recapture appellant number 3 were not taken, even though he had not returned to the ashram after availing the forlorn leave for 10 days. Roman 4, what action has been taken against the erring officials for giving misleading information to this court? Under each heading, the reply has been submitted before us, and from the affidavit we found that the appellant number 2, Jamadar alias Jayaprakash Laguri, has been recaptured in the meantime from village Tagon Ghatu, and he was produced before the London SDGM Keonjhar on 13/11/2025 and has been remanded to judicial custody. And he was on prolonged leave, but did not surrender after the expiry of such leave period. So far as appellant number 3 is concerned, it is mentioned that he had expired on 17/8/2025. However, no death certificate of appellant number 3 has been annexed to the affidavit. Let the London Council for the State produce the authentic document relating to the death of appellant number 3, Nanu alias Naresh Laguri. It is further stated in the report that 2 officials of District Jail Keonjhar were identified and responsible for the misleading report to this court on an inquiry, and disciplinary proceeding has been initiated against both of them for imposing major punishment. Since from the affidavit we came to know that the appellant number, after being recaptured, is now lodged in Keonjhar jail, we asked the London Council for the State to ensure his appearance through virtual mode from jail. Accordingly, the appellant number 2 appeared through virtual mode. When we made a query to him as to why he did not surrender after the prolonged leave period, he said that his mental condition was not good, for which he was roaming here and there. But from records it appears that he stood as a surety for appellant number 3, Nanu alias Naresh Laguri, who was released also on prolonged leave and did not surrender. Stop. When we try to ascertain from appellant number 2 as to whether he is aware that the hearing of his case, criminal appeal, has been fixed, and about the name of his advocate, he named a local advocate of Keonjhar, but said that he is not aware that Mr. A.K. Acharya, London Council, has been engaged to argue the criminal appeal, and he expressed his willingness to have an interaction with Mr. A.K. Acharya about the case, and in view of such statement made by the appellant number 2, the Learning Council for the state shall make arrangement so that relating to the case matter, there will have an virtual interaction between the appellant number 2 and Mr. A.K. Acharya, and the date and time of such interaction will be communicated to Mr. Acharya. Okay. Put up this matter on 4th of December 2055. Stop. A free copy of the order be handed over to the Learning Council for the state. This affidavit is taken on record.
Lordship, a copy of the affidavit also be served upon.
Give him a copy. Let a copy of the affidavit be presented. Served on Mr. Acharya. You give your name so that it will be reflected. Swanshu is present on behalf of Mr. Acharya.
Yes, I am handed over that.
Yeah.
I have handed over that copy.
Any other matter which
Item 2 is there.
item number 2? Yeah. Item number 2. No, item number 2. So that will be that.
Bonai, please.
Morning. They bail केली वाला 30/4/2000
Yes, not electricity will be in this board.
अपन चिट्ठी लिखते हैं रिपोर्ट की देई ना
नहीं
केतर लिखे
27/10/2025
नहीं ता पूर्व
जाएगी
अपन ये पूरा 20/6/2025 रे अपन पहले made a statement that as per the order dated 16/4/2025 he has not received the well-being report. हमर order टा हितला प्रथम order टा 16/4/2025 रे statement में लिखते since this criminal appeal is of the year 2007, Land Council for the state shall obtain instruction about the status of the appellant. That is the first order. तापरे अपन time नहीं चल सकती. So when you made the communication,
26 ପରେ 27 ରେ
total केते थर communication to
26 and 27/10
26
and
27/10. Who is present now? ये प्रेजेंट अछन
ଆପଣ ପରିଚୟ ଦିଅନ୍ତୁ.
Yes, kindly unmute. Please unmute.
ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ.
Yes.
ଆପଣ ନାଁ କଣ?
सर हरिशंकर नायक एसआई बणैतिया सर
Just room. ଆପଣ आईआईसी ଅଛନ୍ତି?
सर नांती से गुडे कोडारे गुडे इंसिडेंट ହେଇଛି जो डकैती केस ହେଇଛନ୍ତି बाहर सर
अच्छा ଆପଣ ହଉଛନ୍ତି ଏସଆଇ ଅଫ ପୋଲିସ
आज्ञा सर
କଣ ନାଁ କଣ?
हरिशंकर नायक
अच्छा ये जो वर्तमान देवराज मुंडा बोली जने व्यक्ति जाकू जे बणाई जिला कोर्ट रे से 302 दफारे आजीवन कारादंड ताकू होईची एवं से क्रिमिनल अपील दाखल करछि एवं ताकू एठू हाई कोर्ट रु 30/6/2019 रे बेल ऑर्डर होईची जेतबेले वर्तमान सुनानी पई आसिला हमें एप्रिल मासरू सरकारी वकीलों को कहलु जे से लोकर विषय रे बुझिकिनी को से अछि कि नाही तो सरकारी वकील वर्तमान कहउचंदी से बणई थाना आईआईसी को दीटा दिथर चिठी लिखि सारे गोटे 20/6 रे लिखिले आउ गोटे बे 27/10 दीटा चिठी लिखिले जे तार वेलबिंग रिपोर्ट दबा पई अपेलेंट रो तो एपर्यंत रिपोर्ट दाखल हेइनी आपनकर ए लोक विषय कोन अछि ज्ञान
ସାର୍ ମୁଁ ତ ସେ ବିଷୟରେ ଜାଣିନି ସାର୍ ମୁଁ ବି ନୂଆ ଆସିଛି ସାର୍ ଆଉ ମୁଁ ସାର୍ଙ୍କୁ ଆସିଲେ ବୁଝିକିରି କରିବୁ ସାର୍
आईआईसी को कहंतु से लोक विषय
ସାର୍
इनक्वारी करी से बंचिची कि नाही कोन अछि ए सब विषय रे तार वेलबिंग रिपोर्ट इमिडिएटली सरकारी वकील पाखु पठेबे ए मैटर आमे आसंता मंगलवार दिन टेकअप करिवु आज होची 20 तारीख 25 तारीख दिन टेकअप होबो ता पूर्वरु से रिपोर्ट आसी पहुंचीबा दरकार एवं आईआईसी
ଆଜ୍ଞା
कहबे
ସାର୍
जे सरकारी वकील बाबूଙ୍କ संगे ମଧ୍ୟ कथावार्ता हेइ जिवे ए विषय रे हला
ଆଜ୍ଞା ସାର୍
आउ
ସାର୍
ए विषय कहीदेवे मध्य सरकारी वकील कहले जे दी थर कम्युनिकेशन कलेनी कोनोसी रेस्पॉन्स आसीनी तेणु से विषय मध्य आसंता तारीख रे हम तंग पचारि कोन पई से रेस्पॉन्स दउना
ଆଜ୍ଞା
लेखंतु
ଆଜ୍ଞା ସାର୍
दी Land and Council for the state has brought to the notice of this court that as per order of this court twice he has made communication to the inspector in charge of Bonai police station to submit report on the well-being of the appellant. But he has not received any response from the IIC. Two reports that is on 26/2025 and 27/10/2020. But he has not received any response. The sub-inspector of police, namely Hari Shankar Naik of Bonai police station, appears through virtual mode and submits that IIC has gone to investigate a case and is not available in the police station, and he will apprise the IIC about the listing of the case and also ask him about the court's order to submit a report by Monday, that is 24th of November 2025, to the Advocate General Office, London Advocate General Office, regarding the well-being of the appellant. Stop. The matter will be taken up on 25th November 2025. The London Council for the State shall produce the report and the IIC of Bonai Police Station shall appear through virtual mode on that day at 10:30 a.m. A free copy of the order be handed over to the London Council for the State. Personal appearance of distance with Yes, sir. Which is that part of that? Yes. 60. What is that, sir? Paper. Judicial.
Yes. Lifetime will be directly something judgment. It's to say reach for like food sar food कोई तो Action criminal law 368 of 91.
Shanti versus State of Haryana.
Yes, ma'am.
Which paragraph is relevant according to you?
Now we shall consider the paragraph 5, ma'am.
Paragraph 5.
Yes.
ପଢନ୍ତୁ।
Now we shall consider the question as to whether the acquittal of the appellants of the offence punishable under section 490A makes any difference. The submission of the London Council is that the acquittal under section 490 IPC will lead to the effect that this cruelty on the part of the accused is not established. We see no force in this submission. The High Court only held that section 304B and section 490 IPC are mutually exclusive, and that when once the cruelty visited in section 490 IPC culminate in dowry death of the victim, section 304B alone is attacked, and in that view of the matter, the appellant were acquitted under section 498 IPC. It can be therefore be seen that the High Court did not hold that the prosecution had not established cruelty on the part of the appellants, but on the other hand, the High Court considered the entire evidence and held that the element of the cruelty, which is also an essential of the of section 304B IPC, has been established. Therefore, mere acquittal of the appellant.
Mere acquittal. Mere
acquittal of the appellants under section 490 IPC in these circumstances makes no difference for the purpose of this case. However, we want to point out that this view of the High Court is not correct, and section 304B and 490 cannot be held to the mutually exclusive. These provisions deal with two distinct offences. It is true that cruelty is a common essential to the both the sections, and that has to be proved. The explanation of section 490 gives the meaning of the cruelty. In section 304B, there is no such explanation about the meaning of the cruelty. But having regards to the common background to this offense, we have to take that the meaning of the cruelty or harassment will be the same, and we find in the explanations to section 490A, under which cruelty by itself amounts to an offense and is punishable. Under section 304B, as already noted, it is the dowry death that is punishable, and such death should have occurred within 7 years of the marriage. No such period is mentioned in section 490A, and the husband and his relatives would be liable for subjecting the woman to cruelty, and the time
any
time after the marriage. Further, it must also be borne in mind that a person charged and acquitted under section 304B can be convicted under section 490A without a charge being there, if such a case is made out. But from the point of view of practice and procedure, and to avoid technical defect, it is necessary in such cases to frame charges under both the section, and if the case is established, they can be convicted under both the sections, but no separate sentence need be awarded under section 490A. in view of the substantive sentence being awarded for the major offense under section 304B. And these are all the submission and we do not find merit in this any of them. Therefore, we confirm the condition.
এইটা কোন ପାଇଁ ଆପଣ ଦେଲେ ଏଇଟା କୋନ ପାଇଁ ଦେଲେ ଆ ଦେହରେ 498 ରେ ତ ଆକ୍ଚୁଆଲ ହେଇନି 498 ରେ ବି କନଭିକ୍ସନ ହେଇଛି 304 ବି ରେ ହେଇଛି 302 ରେ ହେଇଛି ତାକୁ ଏଇ ଯୋଉ ଏଟା ଦେଲେ ଆର ଯଥାର୍ଥତା କଣ
304B ରେ ଖାଲି ହେଇଛି
304 ବି ରେ
yes condition
302 ଅଛି
ନାହିଁ
ଆଉ ତାହେଲେ
କହିଥିଲେ AR 1991 1226 ଟା କହିଥିଲି
କଣଟା
last time you lords
ଏଇଆ
AR 91 Supreme Court
ହଁ
1226
ଏଟା ପୁରା ଏଇ କେସଟା
ଶାନ୍ତି କେସଟା
ଶାନ୍ତି କେସଟା
ଏଟା କହିଥିଲି
ନାଇଁ ଆମେ ଆପଣଙ୍କୁ କଣ ପଚାରିଲୁ ଯେ ଏଇ କେସଟାକୁ ଆଜି ଯୋଉ ପ୍ଲେସ କଲେ ଏଟା କୋଉ କେସଟା ପ୍ଲେସ କଲେ এইগুলা তো ବର୍ତ୍ତମାନ ପ୍ରେସ୍ କଲେ ଏଇ କେସଟା ତ ୟାର ଯଥାର୍ଥଟା କଣ ଏଇ ଯୋଉ କେସରେ 498 ତାକୁ ହାଇକୋର୍ଟ ଇଏ
498 ନହେଲେ 304 ରେ କଲେ ନାହିଁ 498 ଏ ରେ କାଟି ଦେଇକି 304 ବି ରେ କଲେ
ଆର ଯଥାର୍ଥତା କଣ ଏଇ ଯୋଉ ବର୍ତ୍ତମାନ ଆପଣ ଯୋଉ ଏଇ କେସଟାରେ ଆମର ଆର ଯଥାର୍ଥତା କଣ ଅଛି ଆଚ୍ଛା ହଉ ତାପରେ ଆଉ କଣ ଆଣିଛନ୍ତି ଦେଖିବା
ତାପରେ AR 1991 Supreme Court 1142 ମାଇଲ
କୋଉ ପାରାଗ୍ରାଫ
paragraph 3
ଆଚ୍ଛା
if perusal of the section 304B so that one of the essential ingredients that has to be established in that death was otherwise done in normal circumstances. In this case, no doubt, the other circumstance, namely that the death occurred within 7 years of the marriage and that before her death, they have harassed her for a demand of dowry and established. Coming to the other ingredients, we find that the prosecution has miserably failed to establish that death was otherwise done in normal circumstances. The loan counsel appearing for the state, however, submitted that the deceased was young and the death was not due to natural cause, nor it was due to an accident. And the only inference that can be drawn is that it was otherwise done under normal circumstances. In a case of this nature, where the prosecution has failed to establish that it was an unnatural death, it can be surmised that the death must be due to unnatural circumstances. In this context, the framing of the charge and the circumstances that are put to accused under section 313 CRPC also assume importance. The charge was under section 302 IPC and the contents of the charges are to be effect that the death was only due to asphyxia. In the exemption of section 313, it was not even indicated that the death would be due to poisoning. In any event, in view of the facts and circumstances regarding the death, it has become very difficult, rather impossible, to hold that the death was otherwise than the normal circumstances, and consequently we are constrained to hold that this important aspect of section 304B is not met out. Consequently, the appellant are entitled to acquittal of the state offence. In this case, we do not purpose to examine the other submissions, namely that in the absence of charge under section 304B, the conviction cannot be awarded since we are acquitting the appellants on charges of the offence punishable under section 304B IPC. So far as offence under section 498 is concerned, the evidence of PW 1, 2, 4 and 7 would show beyond a reasonable doubt that the three appellants were harassing the deceased and making a demand of a dowry. The evidence show that the deceased was subject to cruelty within the meaning of section 498 IPC for the aforesaid reasons. The conviction of the appellant under section 304B IPC sentence for of 7 years imprisonment awarded against each of them are set aside. Conviction under section 498 IPC and a sentence 2 years are maintained and default clause. The appeal is partly allowed.
तो ଏଇଟା ଏଠି କଣ ଆପଣ କ୍ୱେଶ୍ଚିନ୍ ପଚରାଇନି ଆପଣ ପଚରାଇଛି ଯେ ଆପଣ ୱିଦାଉଟ୍ ଇଣ୍ଟିମେଟିଂ ଡେଡ୍ ବଡି ଟାକୁ କ୍ରିମେସନ କରିଦେଲେ ଆଉ
पुलिस को खबर देना नहीं
पुलिस को खबर देने गोटा पचराइଛି क्वेश्चन नंबर 11 विषय PW11 विषय पचराइଛି PW12 विषय भी पचराइଛି आपको हाँ ये लिखा है PW12 has deposed that on 12 to 10 question number 10 night on his return from work his wife informed that she received a message over telephone that their daughter was killed in her in-laws house and her dead body was cremated without informing them. Only next question number 11 that he came to your house and asked you the cause of death of the deceased and he replied that Pratima committed suicide by jumping into the well in the night and as it was a night it was not possible to intimate him regarding her death. ଆଉ ତାପରେ ତୃତୀୟ କଥା ହେଲା ଏଇ ଯୋଉ 15 number ସାକ୍ଷୀ କହୁଛି ଯେ scientific officer he inspected the house collected swan so scrapping of the wall floor broken glass bangles sari pillow cover and those were suspected to be bloodstains and handed over to the SI. ଏଠି ତ ଆଉ ମାନେ ଇଏ ପୋଷ୍ଟମର୍ଟମ ତ ନାହିଁ so ସେ କେସ୍ ରେ ବୋଧେ ପୋଷ୍ଟମର୍ଟମ ହେଇଥିଲା ତେଣୁ doctor who conducted postmortem examination opined swan so ତେଣୁ ତା ବିଷୟରେ obviously question ପଚାରିବାର ଥିଲା ସେ ବିଷୟରେ most likely ସେମିତି specific question ବୋଧେ ତା ଦେହରେ ଆସି ନଥିଲା ତେଣୁ ଏଇଟାର ଆଚ୍ଛା next case next case ଟା ହଉଛି କଣ
2002
ଏଇଟା ତ ଆମେ ଆପଣଙ୍କୁ କହିଥିଲୁ 2002 ଜଷ୍ଟିସ ଡିପି ମହାପାତ୍ର ସେଇଟା ଲାଷ୍ଟ ପାରାଗ୍ରାଫ ଟା ଯୋଉଟା 14 ନା କଣ
ଟ୍ରାଏଲ ଟା ଆକ୍ୟୁଟାଲ ହେଇଥିଲା ଅପ୍ରିୟ ତାଙ୍କୁ 302 ରେ ହେଇଥିଲା 304 ବି 4 ପେମେଣ୍ଟ
14 ପାରାଗ୍ରାଫ ରେ ଅଛି କଣ କଣ ସର୍କମଷ୍ଟାନ୍ସେସ୍ ଅଛି କମ୍ପ୍ଲେନ ଥିଲା ଏ କମ୍ପ୍ଲେନ କୁ ସେ କଣ୍ଟିନ୍ୟୁଅସଲି ଜଣଉଥିଲା ତାର ଘର ଲୋକଙ୍କୁ ତାପରେ ରାତିରେ ସେଦିନ ହେଲାଣ୍ଡ ହାଟି ଥିଲା ଯୋଉ ଦିନ ଅକରେନ୍ସ ନାଇଟ୍ ଦିନ ତାପର ଦିନ ଘଟଣା ହେଇଛି ଏବଂ 5 ଜଣ ଆପେଲାଣ୍ଟ ଆଉ ଇଏ ଥିଲେ ସେ ରାତିରେ ତାପର ଦିନ ଦେଖାଗଲା ଯେ ଡେଡ୍ ବଡି କିଚେନରେ ମିଳିଲା ଆଉ କାହାକୁ ଆଚ୍ଛା ସେମାନେ ତାକୁ ଡେଡ୍ ବଡି ୱାଜ କ୍ରିମେଟେଡ early in the morning before sending any information of the tragic incident to the parents ଏବଂ unnatural death ବିଷୟରେ କୌଣସି ରିପୋର୍ଟ ହେଇନଥିଲା for registration of the death. Acha, appellants were not initially sure whether it is a suicidal or accidental. It would have subsequently would a plea upon a nele which was found to be a false one. Eti circumstance sold karigini tol of court ro bodhe acquittal order thila.
Acquittal order trial
order ku अच्छा नहीं तल कोर्ट नथिला आपनकर हाई कोर्ट एक्यूटल करथिला ट्रायल कोर्ट कन्विक्शन टाको अपहोल्ड करे देयरफॉर द हाई कोर्ट कमिटेड नो एरर इन इलीगैलिटी इन कमिंग टू द नहीं
तल कोर्ट तो कन्विक्शन एक्यूटल करथिला हाई कोर्ट
अच्छा तल कोर्ट एक्यूटल करथिला हाई कोर्ट कन्विक्शन करथिले सेटा अफर्म करले अपील अच्छा तापर आउ कोन देइचंदी
वॉल्यूम 7 एसिस
157
3048 4 पेमेंट 302 रे हां
तीनटा
एटा जे जो कॉर्पस डेलिक्टी नोट फाउंड थिला सेटा होची आपनकर पैराग्राफ नंबर केते कोटारे आपन को पैराग्राफ ता
पैराग्राफ 4
Paragraph number 4 ରେ ସେ ବିଷୟରେ discussion ହେଇଛି. UU Lalit Learned
Yeah.
Counsel appearing for the appellant argued that in absence of any motive and the corpus delicti, it is unsafe to place reliance on the circumstantial evidence adduced by the prosecution, more so when the said evidence is replete with discrepancies, omissions, and improvements. He pointed out in this regard a part of evidence of the prosecution the courts below themselves have not placed reliance. Therefore, in a case of circumstantial evidence of this nature, it would be dangerous to base a conviction. That was the contention of Mr. Lalit. We don't find much force in the argument of Mr. Lalit. It is a well-settled principle in law that in a trial for murder, it is neither an absolute necessary nor an essential ingredient to establish the corpus delicti. The fact of death of the deceased must be established like any other fact. Corpus delicti in some cases may not be possible to be traced or recovered. There are a number of possibilities where a dead body could be disposed of without a trace, and therefore if the recovery of the dead body is to be held to be mandatory to convict an accused, in many a case, the accused could manage to see the dead body is destroyed. We should afford the accused complete immunity from being held guilty or from being punished. What is therefore required in law to base a conviction for an offense of murder is that there should be reliable and plausible evidence that the offense of murder, like any other factum of death, was committed, and it must be proved by direct or circumstantial evidence, albeit the dead body may not be traced. So this is the thing we pointed out on that day. Number two, in the last paragraph also, last page, that if any false answer is given, that would provide a missing link in completing the chain. That is in page number 167. In this case, the explanation which you have given, ए जो कौन पिठा खाई तार पेट मोड़ीगला एवं ताकू हठात मरीगला, that appears to be false because of the scenario which is presented in the case, that what would have been your normal conduct and you did not take any steps to take him to the doctor, not intimated to the parents, not intimated in the police station. You took him and not disposed of the dead body in the graveyard. You disposed of in somebody's toe. That is the evidence has come. So that explanation that pitha kai ta petto katila ta pare morigala. Yeah, explanation.
Yes, ma'am. PW 11 also says that pithakai do petto katila. PW 11 କହିଛି.
ନାଇଁ PW 11 ପାଖରେ ଆପଣ କହିଲେ, but PW 12 ପାଖରେ ଯୋଉ ତାକୁ ବୋଧେ କୁହାଯାଇଛି ଯୋଉ କଣ ଡେଇଁ ପଇଲା ପୁଅକୁ ଡେଇଁ ପଡିଲା। 313 ରେ ବୋଧେ ପ୍ଲି ଅଛି। 313 ବୋଧେ ପ୍ଲି ଅଛି। 313 ର ପ୍ଲି ହଉଛି ପିଠା ଖାଇଲା। ହଁ। What decisions you have got? appellant ଦେଇଛନ୍ତି ଏଟା ହଉଛି state ର। ଏରା କୋଉ paragraph ଟା କୁହନ୍ତୁ? ପାରା 8 DW2
Schedule 2 was the brother. Schedule 5. Huh?
At the background, para 11 is the initiated with that.
No, no.
The para state is 11. At the real region of the subfunction to tension. Usually, that will be present.
No, who paragraph?
Para 12 man.
अच्छा पूर्ण दिया paragraph 8 कौन कर
Para 12 man.
हाँ
The trial court come to the following conclusion that no illegality has been committed in the trial report given by 0 to 11 and the value for the outpost to the police not being refused to writing immediately there was no need the contention that the original FIR had been supported and concluded by had been sent to the court. The FIR was lodged 30 January 1998 having described by the uncle 011. The FIR was received in the court on 3rd February 1998. There was no intention to dispatch the FIR until the so-called minor contradiction in the version of 7 to 13 did not weaken the case of the prosecution. There was a case where there was no eyewitness and no postmortem to be performed as the dead body was cremated soon after the death. The victim had died while she was in the house of the accused, and the cremation took place in the absence of her parents and relatives. The cause of the death was specifically within the knowledge of the accused person, and the burden of proving it was of them under Section 106 of the Criminal Act. Although Schedule 1, C, and 5, villagers of the village
Dengapadar.
were cross-examined about the time and circumstances under which the deceased was cremated, no suggestion was given to them that she died in diarrhea. To none of the PW, except PW 11, any suggestion was given that the deceased died in natural death due to diarrhea as the result of diarrhea. Dehydration as the result of diarrhea. And paragraph 13 is the
you come to paragraph number 18.
And glaring fact that stands out is that the heartly cremation of the deceased without waiting to her parents or relatives or even informing them of her death. The fact that the accused were present in the house when the deceased died, and the fact that the accused have been unable to explain that she died a natural death due to diarrhea. Diarrhea leads to the
due to diarrhea leads to the irresistible conclusion.
Leads to the irresistible conclusion that after killing the deceased, they hurriedly cremated her in order to destroy the evidence. And for 19 minutes.
No, you come to your paragraph 19 में जो केस टा you come to paragraph number 15. जो 13 14 ये करने paragraph 20 15 number where an offense of murder is committed in secrecy. पढ़ो
where an offense like murder is committed in secrecy inside a house, the initial burden to explain the case would undoubtedly be upon the prosecution. But the nature and amount of evidence to be led by it to establish the change cannot be
establish the charge.
Same degree as required in other cases as circumstances. The burden would be of a comparatively lighter character. In view of a Section 106 of the Evidence Act, there will be a corresponding burden on the inmates of the house to give a cognate explanation as to how the crime was committed. The inmates of the house cannot get out by simply keeping quiet and offering no explanation in this supported premise that the burden to establish its case lies entirely upon the prosecution, and there is no duty at all on an accused to offer an explanation.
Now you come to the next decision जोटा दिया है এটা paragraph number 22 and 23 election दी. likewise Darshan Singh versus State of Punjab. When there are no eyewitness to the crime, the murder of a young woman so and so whose dead body had been disposed of cremated, the Supreme Court affirmed the conviction. In the present case, the accused persons had failed to discharge the burden of showing the circumstances under which the deceased had died. The explanation offered by them that she died out of diarrhea has not been proved by them. The evidence of so and so, DW1 and DW2 in this regard is totally unconvincing and has been rightly rejected by the trial court. Again, that Trimuk case has been quoted there, and the conviction.
But is it on 302 also?
302,
304B. Right. Yes,
this one, we have got also the decision
Yeah.
to that effect that they say decision ku mu dekhutli. I was showing it that 2015 ne madhya kouchandi 2015, just take note of it, 2015 60 OCR 842. It is a Supreme Court decision that homicidal death is chargeable and punishable under section 30 or 304B.
Yes.
842 2015 60 OCR 842 ହେଲା ତେଣୁ ଯଦି ଡାଉରୀ ଆସ୍ପେକ୍ଟ ପ୍ରମାଣ ନ ହେଇ ପାରିଲା ଡାଉରୀ ଡିମାଣ୍ଡ ତାହେଲେ 304B ରୁ ଖଲାସ ହେଇଯାଇପାରେ 302 ରେ କନଭିକ୍ସନ ହବ ହେଲା କିନ୍ତୁ ଯଦି ହୋମିସାଇଡାଲ ଡେଥ୍ ପ୍ରମାଣ ହେଇଛି ବା ସେମାନେ କୌଣସି ଏକ୍ସପ୍ଲାନେସନ ଦେଇ ପାରିନାହାନ୍ତି ଯୋଉ ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେଇଛନ୍ତି otherwise it asila the death has taken place a homicidal death and there is also demand of dowry torture tale both re charge bhi hobo conviction bhi hei pare so that is the decision of the honorable Supreme Court and this so that is why it is said that so even if the death is unnatural it may be homicidal it may be suicidal 304B attract hobo so a case re apankar asuchi first of all hochi ଦି ତିନିଟା statement ରୁ ଜଣା ପଡୁଛି ଯେ death ଟା 7 ବର୍ଷ ଭିତରେ ମ୍ୟାରେଜ ର ହେଇଛି ତାକୁ ଆପଣ dispute କରୁନାହାନ୍ତି death ଆପଣଙ୍କର ପାଖରେ ରହିଥିଲା ବେଳେ ହେଇଛି ସେଇଟା ବି ଆପଣ dispute କରୁ explanation ଦେଇଛନ୍ତି that's a different evidence ଆସିଛି ଯେ right from the time of marriage thereafter also there was demand of dowry ଏବଂ ତା ବାପା ମଧ୍ୟ ଏ ବିଷୟରେ କହିଛି ମା ବି କହିଛି ଆଉ ଗୋଟେ କିଏ ବୋଧେ କହିଛି ନା କଣ soon before death ଅଛନ୍ତି ଯେ ସେ
1.5 months before that
1.5 months before ମଧ୍ୟ ଯାଇକିନି ପହଞ୍ଚିଛନ୍ତି ରାଉରକେଲାରେ ସେଠି ମଧ୍ୟ 20,000 ଟଙ୍କା ମାଗିଛନ୍ତି ସେ 10,000 ଟଙ୍କା ଆରେଞ୍ଜ କରିକି ଦେଇଛି ଏବଂ କହିଛି ଆଉ 10,000 ଟଙ୍କା ପରେ ଇଏ କରିବ ତାର ଡକୁମେଣ୍ଟ ମଧ୍ୟ ପ୍ରମାଣ ହେଇଛି so these are so far as demand of dowry ଏବଂ deceased ଆସିକି କହିଛି ମଧ୍ୟ torture ବିଷୟରେ so demand of dowry torture 7 years of marriage unnatural death କାରଣ ଆପଣ ଯୋଉ natural death କଥାଟା କହୁଛନ୍ତି that is not believable and you have disposed of the dead body এই materials ଗୁଡାକ ଅଛି apart from that the from a particular room the scientific officer has collected something like broken bangles ଆଉ ଇଏ ସେ ଯୋଉ ଇଏ ଯୋଉ ତେଣୁ ଆପଣଙ୍କର କାହାକୁ ବାକି ଯୋଉଟା ଆମେ ଯୋଉ କହୁଛୁ କଣ୍ଡକ୍ଟ ହବା କଥା ଯୋଉ ନ୍ୟାଚୁରାଲ ଡେଥ୍ ରେ ବହୁଟା ପେଟ ଖାଇ ଯୋଉ ପିଠା ଖାଇକି ତାର ପେଟ ମୋଡି ହଉଛି ଆପଣ ଲେମ୍ବୁ ପାଣି ଦେଲେ ତାର ଭଲ ହେଲାନି ତାପରେ ଆପଣ ଯୋଉ कंडक्ट हवा कथा किसी नहीं नांती कौन से डाक्टर को इंटीमेट करना थी साई पड़िशा ये किसी करना थी सेई गारे तांकर रिलेशन रोचन अर्थात जेजे ना अजागर सेई गारे तांकु मध्य जणे ना थी हैज बीन cited as a witness or examiner तेणु एई सर्कमस्टांस रे ताछड़ा जो एक्सप्लेनेशन जोटा कि क्वेश्चन से डिसीजन ने यदि your explanation found to be false then that would be a missing link additional link in the chain of circumstance these are the materials available ତେଣୁ
No, appellant number one is the 85% bed ridden my lord. And they are in custody more than
Mr.
11 years.
Counsel,
Yes,
once
sir.
we hold him guilty, we cannot do any other thing. 304 302 दफारे जनकु जदि आमे कन्फिशन करिवु
Yes, sir.
तार से बेड रिडिन हो कि जहाँ भी हो can we reduce the sentence of except that life imprisonment छड़ा ଆଉ କିଛି ଅନ୍ୟ sentence ଦେଇ ହବ ତେଣୁ bed reading becomes immaterial here तार एज ହେଇଗଲାଣି bed reading ହେଲାଣି ଯୋଉଠି scope ଅଛି କିଛି alternate sentence ku ये करियाକୁ ସେଇଟାକୁ reduce କରିହବ that's a different matter but in this type of cases where 302 is there so Likhun, the land council for the state as well as land council for the appellants cited some decisions which are taken on the hearing this close judgment